let's kick off then. So with the overview from myself and what are the Care Act easements. So hopefully you all are aware that the Coronavirus Act came into force in the last couple of weeks. It was rushed through to come into force, and that there are provisions within the Coronavirus Act which specifically affect the Care Act. And what they do is they modify certain provisions of the Care Act, essentially in order to relax the duties that local authorities have, or certain of those duties, in order to essentially ease up pressures on local authorities during this time. And that's where the word easements come from. You won't find easements referred to anywhere in the legislation. That's from the statutory guidance. And as I say, the context of this and the motivation behind these provisions is fairly obvious. What is needed during this pandemic period is for local authorities to be able to prioritise more effectively what their work load is in respect of social care, so that they can focus on the most urgent and the most acute needs and make sure that those get met. There are expected, of course, to be additional pressures on local authorities, both because of increases of work, of requests for support, some of which will be quite urgent, and also, of course, a depleted workforce as members of your teams are off sick or having to isolate on the basis of the government guidelines. The provisions in respect of social care are to be found in Section 15 and Schedule 12 of the Coronavirus Act. Section 15 is essentially just an enabling section, so you don't need to worry too much about that in itself. The detail is all in Schedule 12, and it's when you get to that schedule that you really realise the full extent of the modifications to the Care Act, and we'll come on to that in due course. The provisions, as I say, have been in force since 31st of March, and the statutory guidance was issued on that same day and has been updated on the 1st of April. And if you haven't already read the statutory guidance, which I'm sure many of you have, then I highly recommend that you do so. I've also just mentioned there on the slide about the ethical framework for adult social care, which will be relevant to local authorities, and they're expected to consider and apply in making decisions and following the approach under the legislation. Both Lee and Peggy are going to discuss that in more detail in their talk, so I'll move on from that now. But before we get on to the detail of what exactly the easements themselves do, there are some important points to note. First of all, the fact that these measures are, of course, temporary. The Coronavirus Act itself is only has a long stop of 2 years, so it's only expected to last for a maximum of 2 years, and it will be kept subject to review. So if the provisions are no longer considered to be necessary, then those will be ended before that 2 years is up. They're also to be used as narrowly as possible. And thirdly, this is a really important point, that although the provisions are already in force, as I've said, they do not automatically apply. The local authority has to take a decision to activate the easements, and that's something that Peggy's going to be discussing in some more detail. But in essence, it's that should only happen when it becomes absolutely necessary. And I've just inserted on the last bullet point there from the statutory guidance that it should only happen when it's essential in order to maintain the highest possible level of services. The expectation is that the Care Act pre-amendment, that is the Care Act as we know it, should be followed for as long and as far as it is possible to do so. So this slide that is up now is just an extract explaining that from the Section 6 of the statutory guidance, and Peggy's going to go into more detail about it. Section 6 of the statutory guidance is really crucial because it explains exactly how you apply the easements, when to do so. The decision to apply the easements that each local authority will make is one that's to be made locally. So each local authority will have different circumstances and will need to apply the easements at different times. The decision itself is to be made by the Director of Adult Social Services in conjunction with the principal social worker or on their recommendation. So it's a joint decision of those individuals. And of course, we'll be taking into account, as I've said before, all the local circumstances, what your current position is. And that decision should be recorded, including all of the evidence that's been taken into account to make that decision. And the statutory guidance does give some suggestions as to what sorts of things you might need to include as that evidence. But it will include things that are fairly obvious, like what your staffing levels are. So really to just provide some level of justification as to why you're taking the activation of the easements at that point. It also needs to be communicated to all your care providers, service users and carers, and should also be reported to the Department of Health and Social Care, and to them you need to provide your reasons as well. This slide just sets out a summary of a table that actually appears in the statutory guidance. This is my own version, but it just to show you the stages that are expected, both pre the easements being applied and afterwards. So it's expected there are these 4 stages. The first 2 stages where you're really still under the Care Act as we know it, the pre-amendment Care Act, and then stages 3 and 4 when you move on to the easements being applied. So what are the actual key changes to the Care Act duties? Well, once you as a local authority have actually made that decision to activate the easements, and only when you do take that decision, then the local authority is no longer under a duty to do certain things. And some of those things I've set out on the slide there. That will be carrying out needs assessments and carers assessments, carrying out financial assessments, although there is a caveat there that if you haven't done a financial assessment, then you will not be able to charge, although you will be able to do a retrospective financial assessment for that period later, and then we'll be able to charge for the period, but you can't actually charge at the time if you haven't done that financial assessment. And then the last bullet point there, which is probably the most crucial one, and Lee's going to be discussing in some depth, but that is that there will no longer be a duty to provide services to meet assessed needs unless a failure to do so would result in a breach of the person's convention rights. And that applies to both the service user and to carers. There are some other changes as well, such as in relation to duties on for young people transitioning from child to adult care, but these ones are the key ones that are worth mentioning. Really crucial to note that it isn't, although there is no longer a duty once the easements are applied, there is still a power to do all of the above, so it's just that it isn't a duty. And also important to note that the provisions do have retrospective effect. And that means that they will apply to any of the duties that arose before the Coronavirus Act came into force, as well as to those arising after. So it isn't just going to be your new cases, it's going to be where potentially there was already a duty, whether that's in respect of an assessment or a duty in respect of reviewing a care and support plan, for example. Also, finally, important to note that there is a lot that isn't changed by this legislation. You still have lots of duties in the Care Act that are enforced. I've included there the well-being and prevention duties, they still matter. The provision, information and advice, that's expected to be something which you may have maybe particular importance at this juncture, to try to assist people who need signposting to services as people's needs for support grow in these testing times. Your safeguarding duties are also not affected, so they still need to carry on as usual. And finally, the other pieces of legislation that are relevant to social care, so particularly the Mental Capacity Act and the Equality Act, are not affected. The Mental Capacity Act, we are expecting there to be some separate guidance in relation to how deprivation of liberty is dealt with during the pandemic period, but that is not affected by these easements in the current Coronavirus Act. So with that little whistle-stop overview done, I'm going to pass over to Peggy, who's going to discuss how and when to apply the easements.
Thank you, Zoe, for that. Yeah, as Zoe has said, my third of the talk is going to be on activating the easements, and then Lee at the very end is going to bring up with the actual application to individual cases. And I just wanted to make that distinction clear at the beginning, and that's why I've referred at the top of the slide to macro and macro decisions, because I wanted to draw out what, in my experience or my reading of the guidance, is not that clear all the time. So as I read the guidance, it distinguishes between macro or systemic or policy-based decisions that are made whether you activate the easements, and then a more micro level decision on how those easements might be applied in relation to each individual service user or individual care package that you're looking at. So I'm just going to be talking on a macro policy base. If you give me the next slide, please. So as I said earlier, two categories not set out as clearly as they could be, wondering why this was, and I was thinking, postulating, speculating that it might be because there's a tension between the individual duties in the Care Act. So we all know duty under Section 18 is owed to the individual. They can apply it or they can enforce it through judicial review in the courts. It's not a target duty, for example, as Section 17 under the Children's Act. So individual duty, the modifications made by the Coronavirus Act modify those individual duties. So they also are individual modifications. But the guidance then brings this more systemic policy-based decision on activating that power to apply the easements. And my speculation is that central government possibly wanted to ensure consistency among local authorities, to ensure consistency between service users, and two, because I'm sure you've seen the same as I have seen, there's been some reports on social media, on the mainstream media, that some local authorities may have jumped the gun a bit. They may have said to their social workers, we're not doing anything anymore. So central government may have wanted to keep the control to make sure that there wasn't, as I put there, possible local over-enthusiasm in the application of the easements. Next slide. Thanks. So that's in the statutory guidance. Zoe told you about that. And all I want to bring up from this particular side is a third bullet point. So we all know statutory guidance, one needs to follow it unless there's good reason not to. Sometimes local authorities do have good reason, particularly with guidance like this that has been issued quickly. It doesn't always have, might always not be what were expected. So for example, you recall in the care and support guidance, there were some difficulties in that. But the point I want to make is in paragraph 18.3 of this Schedule 12, it states that a local authority must comply with guidance of Secretary of State directs. So if you've not, undertaken your activation easements decision and someone makes a complaint, service user or a stakeholder, to the Secretary of State, they may, after investigation, look at that and say, well, off you go, London Borough X, and please make that decision. They may direct you to do so, and you will have to follow that direction. And again, just in the last bullet point there, I speculate is this again because of the need for more centralized control in these very difficult times that we're in. Next slide, please. So what macro decisions need to be made? So as Zoe pointed out, there's the four main easements. There are others, but the four main ones will concentrate on assessments, financial assessments, preparing and reviewing care and support plans, and then meeting assessed eligible needs. Zoe pointed out the 4 stages and the 3 decisions that we need to make. Draw out some points. First is that the stages aren't sequential. So in the guidance, you've got stage 1, stage 2, stage 3, stage 4, but it does make clear that they don't have to be sequential. So you don't have to go from 1 to 2 to 3 to 4, you can go from 2 to 4. The point I want to raise, and I put there, is that since you have to evidence the decision to implement stage 3 or stage 4, you may find it more difficult to evidence that if you've not at least indicated or shown that you've given consideration to implementing stage 2, which you recall is the flexibility under the existing Care Act provisions. So while you don't have to do it, I think I would suggest that you would want to address your mind to it because they are listed in terms of increasing importance in the easements. And then the last point there, you don't have to implement all the easements at the same time or at the same stage. So again, it's not a one size fits all. Zoe mentioned the localized approach that they want you to take. You may think, for example, best to activate the easements for financial assessments and care and review plans, and that will free up sufficient resource that we can still stick with our Care Act duties under assessment and determination of eligibility. That may be a decision for you, but just to clarify that they are those separate decisions in relation to each easement and each stage. And again, I would suggest document it somewhere. Don't know how many of you follow social media, but there is talk on the legal social welfare type social media that these decisions, if local authorities take them in a blanket approach type way, people are looking to challenge them if there's a way to be challenged. Next slide, please. Stage one, as Zoe said, no decision needed. You continue as you are. Next slide. Stage two, this is the policy decision to remain under the existing Care Act provisions, but you make a decision on a systemic level across the local authority to change, delay, or cancel service types under the Care Act. I've highlighted or italicized service types there just to bring home to you that this is a macro level decision. So again, a decision the local authority will not offer a certain service type. The examples given in the guidance are home care or supported living. I've added there that they've given us no clarifying details because it seems to me, and I saw at least one panel member's eyebrows raised, that there's a pretty big thing to say we're not going to be offering home care or supported living. It's pretty huge. The way I've tried to understand it is that, as we all know, once we assess needs, it's for us to meet them, we must, but the local authority can choose the way in which they meet them. So I think that's what that's directed at. So if we have chosen in the past to meet a need through a supported living placement, we may decide that actually that's very resource heavy. There's a lot of personal assistance that are needed and there just aren't the personal assistants around at the moment. And a more or a less resource heavy way of meeting that need is to place that person in a more shared type accommodation or in a Care Act. That's my speculation as to where they may be going there. If you give me the next slide, please, Zoe. But you'll see there at the end of the first bullet point, I said practicality. Is that really possible? And then the last bullet point, I said, look, we've been operating under conditions of vast austerity for the last 10 odd years. Adult social care services, care packages have been cut to the bone. I'm not really seeing there's a lot of room for the flexibility that central government Secretary of State is looking for in stage two. I have given two examples. These are my examples, not in the guidance. At the second bullet point, we could use more technology to meet certain needs. I've given the famous example of toileting needs. Yeah, that's the McDonald case that went up to the European Court of Human Rights. So in that court case, you know, she wasn't incontinent, but she had difficulties with toileting. They say, well, you can use incontinence products at night, so we didn't have to put a carer in. It may be now that if one person needs, a service user needs a carer 4 times a day for toileting needs, we can say, well, you can use incontinence products during the day, so we only need to come in twice a day. These are just examples. I'm trying to see where the guidance is coming from, but it is a possibility. Next slide, please. So that's stage 2, existing Care Act. Stage 3 is activating the easements within the Coronavirus Act, policy-based decision that you will not be subject to decision to assess, consider eligibility, and review. And I've added there, those are my additions, added there in bold, in accordance with your Care Act duties and guidance. Because you'll hear from Lee a bit later on that you just can't stop dead. That's what a lot of the narrative on the media has been, Care Act duties stop dead. There's still going to be a residual obligation to do some sort of assessment, some sort of review if needed, some sort of consideration of exactly what you're providing to an individual and then notifying them of that. So it's just, you don't have to do the bells and whistles version that we have to do at the moment. Second bullet point there, the guidance doesn't mention it. So that table that Zoe had earlier in the slides, it's not mentioned there in that table and in the guidance. But this stage 3 must apply to all the easements in Schedule 12. So it must apply to the duty to conduct financial assessments, provide care and support plans, as well as the duty to meet assessed eligible needs for care and support. So that all fall within stage 3. Thank you, Zoe. I think you missed one, did you? Yeah. Yeah, this is effectively saying what I was saying before. There are separate decisions under each easement and for each stage. They can be linked, they can be made at the same time, they can be based on the same or similar evidence, but just document that you've addressed your mind to each and every easement and every stage. And the last bullet point there, flexible, localized approach is the gist and the thrust of the guidance in relation to this. So no blanket decisions. It looks like if you do that, it's a knee-jerk reaction, it's a panic reaction, and more likely to be challenged in the future as regards that. Thanks, Zoe. This was in Zoe's slide, so I'll just pick out the phrase in bold when you take the decision as to stage 3, when it's no longer reasonably practicable to comply with your Care Act duties in those circumstances. That to me is a threshold test when you evidence your decision that you ought to apply. And I've highlighted it here because we'll see in the next slide, if you could turn over, Zoe, that there are other indications in the guidance as to the threshold to apply that on a lay person's reading could look a lot higher. So for example, the threshold says where the impact of the pandemic makes it unachievable or untenable to be subject to your Care Act duties, or where it's essential to maintain the highest level of service. These are very, very high thresholds. My view or suggestion would be when one is applying the no longer reasonably practical test, that the context in which a judge will decide as to what is no longer reasonably practicable will be in the light of, is it unachievable? Was it untenable? Have you tried to maintain the highest level of service? So we're looking at a pretty high test here, I'm thinking. Again, though, and I think I'll talk about it a bit later, that high test is going to be in the context of these difficult circumstances. So when one is assessing the reasonableness and the proportionality of it, then the high threshold might be mitigated, likely will be mitigated in that way. And I've just said the procedure for making the decision making is in the guidance, and Zoe took us through that. Next, please. Right, stage 4. This is the one that's got the media attention, and that Lee will talk about more in relation to individual cases. This is once you've made the decision to activate your easement, can you actually, in an individual case, cut their or withdraw, change, cancel, delay their care package because of coronavirus or the effect of the pandemic? And what I gather from the guidance is that before you make those individual decisions, you must make a policy decision to make what is called a whole system prioritization of care and support across adult social care. That's the phrase that they use. And for me, that simply means that before you can decide that you're only going to meet previously assessed eligible needs for care and attention to a level consistent with your human rights obligations, you must make this policy decision to have a whole system prioritization of care and support. Thanks, Zoe. Again, for me, I mean, the guidance has been done in a rush under very difficult circumstances, so we have to give them a wee bit of leeway. But again, for me, it's been a wee bit unclear at this stage in that they've conflated, for me, the two types of decisions, the macro and the micro. So they're trying to give guidance on both, which is fair enough, but they haven't teased it through. So just to tease it through again, first you make the relevant easement decision, then you look around and you think, uh-oh, I'm actually having difficulties delivering care to individual A and individual B. I need to decide whether to feed individual A or whether to bathe individual B. And when you're faced with that type of decision, and that's an example given in the guidance, then you think, I need to start thinking about activating stage 4. Thanks, Zoe. Right, so the procedure again for decision making there is in the guidance, how to prioritize. Now this I thought the guidance were being a bit naughty about, because they give us a lot of guidance and other things, but they've taken a very hands-off approach into exactly how we prioritize. And this is going to be the nub of it. This is going to be the bit that puts you really right in the firing line for any prospective challenges. So the guidance takes a hands-off approach. They say it's a matter for you, taking into account your local knowledge, your local resources, your local strengths and weaknesses, which is fair enough. They do give some indication. You must prioritize care so the most urgent and acute needs are met. Lee will give you more guidance on that because they'll be congruent with your human rights obligations. The suggestion or the example, I had to put it in very weak terms, in the guidance is to what they call RAG rate your care packages. So you would have divided them into high, medium or low in relation to the complexity and risk of them. And then you make a decision across adult social care to only meet high care packages or only meet high and medium. So remember back to the days when FACE happened and you only met critical needs or you only met substantial and critical needs. It's similar to that in my view. I make the point there that each individual care package might also be RAG rated. So they may have within their high needs, medium needs, low needs. And again, you can make the decision across adult social care to only meet high needs within any one care package. Thanks, Zoe, you can go to the next one. They're repeated for some reason. Thanks. Yeah, next one. Next one, please. Yeah, thank you. So those are the 4 stages in the activating the easements. And these are just some initial thoughts, perhaps to generate some questions. Let's see, we've got at least 2, or to generate thoughts when you go away. It's a public law decision, and you can be challengeable as such. So general public law rules apply. Evidenced, reasoned, and reasonable. This is of vital importance in the guidance. They go on about this a lot. So you must evidence your decision, reason them, and reasonable them. And make sure they're reasonable. One question we did get is what views on actions might have been taken by local authorities prior to the guidance. And I'm assuming that that question, let me get rid of it again. I'm assuming that that question is related to, you can't take any decisions before the provisions came into effect on the 31st of March, as Zoe pointed out, but perhaps you could have done some investigations prior to that. So you could have started your evidence gathering as to what your staffing levels were, or started to RAG rate your care packages. You couldn't, or you have stopped or withdrawn or changed any care packages based on the Coronavirus Act easements before the 31st of March and before you've made these decisions. But in practice, what you may have done, where the confusion may be arising, is that some local authorities, for example, for social distancing reasons, had to adjust the way they met needs. So they might have had to close a daycare center because they just couldn't maintain the social distancing rules in the daycare center. So that might be a withdrawal of services, but it's not for Coronavirus Act reasons, so it's separate. So you could do those kind of things before you made these easement activation decisions. Right, then proportionate. Sorry, we're still back to the other one. Yeah, proportionate. Just make to the point that this is the decision-making procedure as well as the outcome. Guidance is focused on the outcome, but for you guys, I want you just to remind you that the decision-making procedure can be proportionate as well, because we're not looking, or the Act is not looking at burdening you with additional admin duties. And what it's looking to do is to remove or reduce the burden on you. So again, your decision-making procedure, the amount of evidence you get, the quality of that evidence can be perhaps not as high as it would have been a month ago. Thanks, Zoe. Public sector equality duty, Zoe touched on that. No easements to that. Please document that you've had it. An easy way of having a lawful decision-making process. The ethical framework for adult social care. Lee goes into much more detail on this. The only point I want to draw out is that the guidance says local authorities will be expected to observe the framework. My query is, or what I'm going to throw out there is, what exactly does expected to observe it mean? Is it similar or weaker to have regard to? And there's a lot of case law on that. Do we just have to read it? Do we have to consider it? Do we have to apply it substantially? Something that local authorities are going to have to get to grips with. Thanks, Zoe. Personalisation and co-production, the same issue. The guidance states we should continue to respect the principles of personalisation. That's person-centred care. Co-production, that's involvement, inclusion with the carer and the service user. Again, should continue to respect. Is that weaker than have regard to? Is that even weaker than expected to observe? You know, what do we do there? If we simply can't co-produce, is that the end of the matter? So an issue that's at a red flag. Next one there, hospital discharge service requirements. I just raised that because that's something obviously a lot of your frontline officers would have been redeployed to meet your obligations under that. That's going to affect your proportionality decision as to whether you move from stage 2 to 3 to 4. Zoe, please. Oh, and the last stage, query asked, is there a duty to consult? No statutory duty to consult. As you all know, the general principle, no common law unless there's been a promise, so don't make one. Unless the consulted in similar circumstances before, we can say these are exceptionally extraordinary circumstances, so that doesn't apply. And then exceptional circumstances where the nature of the relationship would create conspicuous unfairness, e.g. withdrawal of a benefit. So here we're obviously looking at withdrawing or changing benefits, so that potentially applies. My initial view is that no, a consultation, 12-week consultation, that is putting burden on local authorities, not reducing it. And where, you know, the guidance does say we have to take into account the ethical framework and to take into account co-production and inclusiveness, then the more of that is done, the less likely it would fall within the exceptional circumstance that one has to consult. But again, something to think about. I think those were my slides. This is the first one that belongs to Lee.
Peggy, thank you for that. Before we go on to my part, can I ask, and I see you've muted your mic, but I was going to ask you a question if I could. Do you have a view on what local authorities should do if they've gone through the process and made their decision to implement the easements? What they need to do by way of keeping them under review or using the information about the changing situation demands on services to feed through to decisions in individual cases? Is there anything in the guidance that helps us on that?
I think in the guidance there is, when one is looking at stage 4, there is guidance as to keeping it under review. And I think it's 2 weeks, although I have to double check that. But because the thrust of the guidance is one has to be flexible and responsive to local conditions, my suggestion would be a regular review would be needed. Because, for example, you may find that over the peak period, which is meant to last for what, it was meant to peak in the next week and a half. After that, as we go down the curve, and for example, if an antigen comes in and so we can test people and know they can go back to work, we'll have to take into account those types of material change of circumstances. So I would be looking for regular reviews. In a review, you don't actually have to look at everything. You just have to effectively open the decision saying, I'm reviewing, this has changed, this has changed, this has changed. Does it have any change in our decision? So again, we're not looking for burden on the review, but bear it in mind, yes.
Yeah, because I suppose it could be that the pressures that led to the withdrawal of, let's say, domiciliary care support or supported living could have eased, and so that those services could come back in. You're still working within the easement, but you might change what you decide is a service you can now offer.
Yeah, I agree completely.
Yeah. And I wonder, I think the plan is for me to talk and then for there to be questions and answers at the end, but I wonder if we take a couple of the questions now, just to mix things up a little bit. I see one of the other questions we've got is about direct payments and family members, and we're asked whether or not, although the guidance doesn't expressly deal with this, whether it would be appropriate to pay a family member during this period to provide care and support. My instinct on that is to say, yes, the local authority already has a power to provide direct payments to family members, but ordinarily that isn't done where the family member resides in the same household as the person receiving care. But there is a power to disapply that prohibition on a case-by-case basis. And I would have thought, given the impact of or the potential impact of paid carers going in or personal assistants going into someone's home to deliver care, there is a very clear reason why it would be appropriate to deliver care have care delivered by a family member in the same household. So I think in these circumstances, that's probably a good thing to do. I don't know if Zoe or Peggy have a view about that.
I did hunt for guidance on that, because that is a question that has arisen before. My local authority has given guidance, and they say they do that. But I would echo what you say, Lee, that these are extraordinary circumstances and they can be disapplied for those reasons.
Thank you. Okay, fine. So I'm going to go on and talk about actually doing assessments of individuals under the Care Act, under the easements whilst they're in force. And I've given some quotes at the outset from the guidance about the assessment process. Zoe, can we go on to the next one, please? So we're told that they're very difficult decisions, as Peggy says, though. Unfortunately, the guidance is rather, I think Peggy's term was hands-off on the difficult stuff. And that's certainly my view as well about when it comes to making individual assessment decisions. The guidance is really quite light and doesn't give much assistance to local authorities about how they should do it. When I was looking at the guidance, I saw reference to the ethical framework, and that's mentioned quite a lot, and said that in making decisions, reference should be had to it. And I thought, well, I'll go and look at that. That's going to be very interesting. That's where the answers will lie about how to do this assessment process. But unfortunately, I was rather disappointed. When you get to it, it's not really worth looking at all. But I will take you to it, because we're supposed to take it into account when conducting our assessments. So I'll tell you what it says, but it won't be of tremendous assistance. We've got, again, there reference and guidance assertion that it's crucial that local authorities are able to evidence their decision, demonstrate their professional judgment applying the ethical framework, and where necessary, record that they have considered the convention rights of the individual. And the next slide, please, Zoe. Oh, sorry, just back one. Sorry, I think I may have got confused. Anyway, I think I've missed a slide. But anyway, the point is that the guidance makes very clear that local authorities are still conducting assessments. You're not conducting assessments as required under the Care Act, but you still have to make a decision in each individual case about what services you will provide. And although the framework of the Care Act about how you make decisions and deliver services to people is suspended once the easements are in force in your local authority, you've still got to make an assessment of what you will provide to individuals presenting to you looking for services. So the question is, what should the assessment process look like? What should it take into consideration? The next slide, please, Zoe. And before we get to looking at what the assessment will consider, just some practical points. The guidance says it may not be possible or necessary for assessments to be face-to-face. For obvious reasons, we're trying to avoid face-to-face contact between people, and particularly with vulnerable people. So the guidance says potentially use a third party or an allied professional to carry out needs assessments. I suppose that could be if there is a district nurse visiting somebody or another professional delivering care. You could ask them to gather and collate information for you. It also talks about supported self-assessments. I've never seen self-assessments work very well, and I think in these times when we are looking at making really very quick decisions and potentially very difficult decisions, I don't think a self-assessment is likely to be a very useful tool. I think the third proposal in the guidance, assessments using telephone or video calls, is likely to be much more usable than self-assessment processes. So I think having conversations with people to gather information, ask questions about their daily life and their functioning, and to have an exchange with them and to get to the bottom of what their situation is likely to be far more efficient than trying to set up a self-assessment process, which is almost certainly going to leave gaps and be a much more lengthy process. So I think picking up the phone, having Skype conversations with people is likely to be far more appropriate than anything else. Can I have the next slide, please, Zoe? So turning then on to the ethical framework, which, as I've said, the guidance says is something we've got to show we've had regard to when we're making our decisions. The framework, as I say, is actually not all that helpful on this process of assessments. What it actually does is to set out 8 principles, which are very high level sort of aspirational statements of principle which don't really give any useful guidance as to how you make decisions in individual cases. So I'll just rattle through them. There's respect, reasonableness. There's a little bit more narrative in the document itself, but this is pretty much all that it says. Respect, reasonableness. My favourite one is the last one, actually, community, number 8. Thanks, Zoe. Community. This principle is defined as a commitment to get through the outbreak together by supporting one another and strengthening our communities to the best of our ability. Well, I mean, that sounds great, but quite how that helps a social worker decide what services they're going to provide to somebody is completely beyond me. So the ethical framework, I can't say ignore it, because as Peggy's pointed out, the guidance says we've got to have regard to it. But I don't think it's somewhere to look for much help about how to actually make decisions in individual cases. Can I have the next slide, please, Zoe? Thanks very much. So as it has been trailed, the amendments to the Act mean that now local authorities, once you decide to implement the easements in your area, won't have a duty to meet needs as per the eligibility criteria under the Act. Instead, you'll only have a duty to provide services if it's necessary to avoid a breach of an individual's rights under the European Convention on Human Rights. And the guidance reminds us of that and says that points out the rights under the Convention which are most likely to be relevant are Articles 2, the right to freedom from inhuman and degrading treatment, 3, the right to 2, right to life. I think I've copied that from the guidance, but it's not very clear. But Article 2 is the right to life, Article 3 is the right to freedom from inhuman and degrading treatment, and Article 8 is the right to private and family life. So what I'm going to do now is talk about what those convention rights actually mean in the social care context, in the context of delivering or withholding welfare support from people. And the next slide, please, Zoe. Thanks. So Article 2, the right to life. Everyone's right to life should be protected by law. No one deprived of his life intentionally, save in the execution of a sentence of court. And Article 2 is not an absolute right. It is possible, theoretically, for the state to take people's lives. But the other thing to mention about Article 2 is it's regarded generally as having 2 elements. It's got a negative element. It's that the state can't take people's lives, subject to certain very limited exceptions. But it's also got a positive obligation. The state's got a positive duty to preserve life and to take steps to ensure that people don't have their lives taken from them. But in the context of care and social care provision to maintain life, there is no general duty from Article 2 to provide care to prevent death. But clearly, if you were looking at withdrawing a service which had the effect of putting somebody at risk of death, then it's certainly at least going to be arguable that the state's decision is one which engages Article 2 and potentially breaches Article 2. And all of the process that the local authority should be following here is about prioritising and making sure that those people with the most severe needs get a service. And clearly anyone who would be at risk of dying without the provision of services is likely, almost certainly, going to be at the very top of the local authority's priorities anyway. The next slide, please, Zoe. Article 3 is the prohibition on torture. No one shall be subject to torture or inhuman or degrading treatment or punishment. And again, we might think, well, what's this got to do with local authorities? We're not going around torturing people, but it's clear that, again, Article 3 has got this negative element of the state can't do those things to people, but it's also, Article 3 has a positive element that the state's required in certain extreme circumstances to take steps and to deliver services to avoid people enduring really serious hardship and suffering. And really the leading case on that positive element of Article 3 in the context of welfare support is this case of Limbuella, which is a House of Lords decision which was all about the failure to provide support to asylum seekers who were then left destitute. And what Lord Bingham said in that case was that the treatment is inhuman or degrading if to a seriously detrimental extent it denies the most basic necessities of life, and that it must achieve a minimum standard of severity. And then the court said, in the context such as this, where it's not about the state deliberately inflicting harm, but it's about the absence of money and resources to provide services, the court said that the threshold is a high one. and that there's no general duty to house homeless or provide for the destitute. If you can have the next slide, please, Zoe. But the court, Lord Bingham went on to say that he had no doubt that the threshold for Article 3 would be crossed if a person with no means for support was denied shelter, food, or the most basic necessities of life. And that this would be when someone is facing the prospect of serious suffering caused or materially aggravated by the denial of, in this case, shelter, food, and the most basic necessities of life. And the same, in my view, would apply for somebody who has care needs, who needs assistance with washing, toileting, changing themselves if they're incontinent, that if they were to suffer, if they were to be left without services, which meant that they were suffering seriously as a result of being left in that condition, then it could amount to a breach of Article 3. But the point to take from this case is that the threshold is a very, very high one, because we're talking about the absence of money and funding and services, not the state deliberately inflicting this situation on somebody. So that's Article 3. If you turn on to Article 8 now, the next slide, Zoe, thank you. So Article 8 is everyone has the right to respect for his private and family life, his home and his correspondence. And so again, you might ask, well, what's this got to do with local authority social care support? Well, if we can have the next slide as well, please, Zoe. Article 8 again has got this slightly extended meaning. So I've given you a reference to a case, the European Court of Human Rights case there, where the European Court of Human Rights said that Article 8 doesn't just concern itself with private life and family life in a sort of obvious literal sense, but that Article 8 is engaged where somebody is enduring treatment which isn't quite severe enough to breach Article 3, but nevertheless has an effect on somebody's physical and their moral integrity. So Article 8 can be like a lower threshold version of Article 3, where we're talking about treatment and circumstances which really challenge people's moral and their physical integrity. And an example of Article 8 being relied on is the MacDonald case, which Peggy mentioned, and I'll come back to in a minute. Sorry, Zoe, thank you. Great. So I've just given you a couple of cases which considered, or where claimants tried to rely on Article 8 to compel the state to give them certain welfare support. And the first case I've given there is Anya Fujeva in Southwark, which was a series of 3 cases, again, asylum seekers who were saying that in various circumstances, the care and the accommodation being provided to them by local authority was deficient and amounted to a breach of their Article 8 rights. And all of those claims failed. If we can go on to the next slide, Zoe, thanks. Lord Wolfe said that there was no specific criteria for a positive duty under Article 8. And the court also went on to say, actually, where we're talking about a situation, as in Anya Fujeva as we are here, where we're looking at the absence of support, and again, not the deliberate infliction of harm, that really the threshold for a breach of Article 8 is about as high as a breach for Article 3. So very, very high threshold for you to say that Article 8 is breached by the absence of services. And if we can go on, please, Zoe. And MacDonald is that other case which we've mentioned, and as Peggy said, the facts of this, many of you will remember the former ballerina who had a series of strokes, and she wasn't incontinent, but she couldn't get herself to the toilet during the night, and she had a carer provided for that purpose. But then the local authority said, well, actually, no, we're going to meet your needs by offering you incontinence pads, and that went to the Supreme Court. And Baroness Hale said very, very firmly this was a breach of Article 8. All of the other justices disagreed with her and said, oh no, it isn't. This clearly isn't a breach of Article 8. So it just again shows what a very high threshold it is for there to be a breach. Clearly, many people would say, not a dignified situation for Mrs. MacDonald, but not so serious as to amount to a breach of Article 8. And if we can go on to the next slide, Zoe. I've given thank you, a couple of quotes there from Lord Brown, where he confirms that Article 8 can be engaged in the social welfare field, where you're talking about the withdrawal or the absence of support. But he goes on to say that emphasise that the threshold is very high. He referred to the Anya Fujeva case, which I've just taken you to, which says that it's pretty much akin to an Article 3 threat test. And he goes on to emphasise, the next slide, please, Zoe, that the margin of appreciation, the deference given to the state here, where it's allocation of scarce resources, is very broad. So basically, he's saying Article 8 isn't going to be something you can rely on to compel the provision of social care support. And I've given the quote continues with some other cases which from the European Court, which he says emphasise that the threshold is an incredibly high one. But if we go on a couple of slides, so thank you to Bernard. This is a sort of an example of where Article 8 arguments can succeed in the context of social welfare provision. Bernard and Enfield, really quite extreme facts. The claimant and her husband, the claimant was a woman who was wheelchair bound. She lived with her husband and they had 6 children, and the local authority had failed to comply with its duty under the National Assistance Act to provide suitable accommodation for her, and the circumstances were really quite grave. Can I have the next slide, please, Zoe? The wife was doubly incontinent, and because she couldn't get to the toilet, she was having to urinate and defecate on the living room floor, often in front of the rest of her family, and she wasn't able to play a part in taking the children to bed and those sorts of things. An Article 8 breach was very clearly established there, and she got damages of £10,000. So that is one of the fairly few examples of Article 8 succeeding in the social welfare context. And again, really quite extreme facts, and emphasises, I think, that the threshold or the type of situation you need to be in before Article 8 comes into play to compel the state to provide services is quite a high one, and extreme circumstances. We can have the next slide, thank you, Zoe. So that's a quick run through about what the relevant convention rights are and their thresholds as applicable in the social care context. Just want to talk briefly now about what can happen to these assessment decisions that you make under the easements process, and how you might think about amending your assessment forms and processes to meet the challenge. The first point to emphasise is that, of course, these decisions are still amenable to judicial review. It's not a free-for-all. Local authorities do still come under the review of the court, potentially. And there's a very important difference about how the court would approach a judicial review of an assessment about human rights breach or not. Whereas in a judicial review under the Care Act, the court will show a degree of deference to the social workers and their expertise. But in a human rights challenge, the court can't say, well, there's a range of opinion and we'll accept that the local authority made a reasonable decision about Article 8 breach here. That isn't the way it works. The court in a human rights case will always make the decision itself about whether there has been a breach. So your decisions are effectively second-guessed by the court in all human rights cases. So it's not just a case of following a process and then telling the court to leave your decision alone. The court will always be able to retake the decision. Now, the next slide, Zoe. I've reminded you there of what the guidance says about what the assessments should look like. Again, rather hands-off. We're told that the principal social worker should ensure proportionate and professional recording is maintained. What does that mean? Not very helpful. And again, remind you that we're told it's important that local authorities can evidence their decision and demonstrate their professional judgments. But again, that seems fairly obvious, but not very illuminating. And so I've gone on to give some suggestions of what I think you might want to consider in your assessment forms, and using different assessment forms for these purposes. So thank you, Zoe. So I think we should probably be looking at bringing in new forms, which are much simpler, much shorter, and don't follow the Care Act eligibility criteria as most local authority assessment forms do at the moment. And I think really what you're looking at is a short but comprehensive description of what a person's presenting problems are, their disability, their illness, and the impact it has on their daily life, what it means they can and cannot do. And then you need to identify what the critical care elements are. What are those things those needs which, if weren't met, would be engaging Articles 2, 3 and 8? What are the care elements that are crucial to life or to their dignity and personal integrity, things like toileting and washing? We're less interested, in the context of avoiding a human rights breach, in things such as social interaction and ability to go shopping and engage in employment. Those are very unlikely to engage the convention rights. So we really need to ensure that we're focusing on the question of those matters which engage the human rights test. And I think it's also important to describe protective factors. Now, it's very difficult or it's rather controversial under the Care Act, the extent to which or how you take into account care being provided informally by a family member, whether that means that needs are therefore not eligible. But we can sweep all of that aside for these purposes. But what you need to, and it's very appropriate to take into account, is what do they have available to them to meet their needs and to prevent them suffering really serious harm at the moment? Do they have family members living with them or neighbours who are assisting them? And then I think it's probably also worth you having forms that set out some of the descriptions of the convention right threshold, because this will be very new stuff to social workers who won't be used to applying these thresholds. So some sort of drafting notes within the forms that take people to what the thresholds are might be very helpful. And can we just go on to the next slide, please, Zoe? And as to what your analysis should be, well, I think it doesn't need to be elaborate. The thresholds for convention rights breaches are high, and so really it should be fairly obvious when you've got a case which is pushing towards that threshold. So I don't think we need complicated or elaborate analysis. And the point as well I've emphasised is that this process is designed to reduce the burden on local authorities, not increase it with complicated human rights analysis being required in every case. So that's what I think is worth considering before the easements are brought into force, having some work done so you've got forms and processes in place which ease the burden on social workers. And finally, I think the last slide, Zoe, thank you. I think it's probably worth as well local authorities considering how they're going to manage this process. And it's given that this is a very different way of working and assessing, it's probably worth having a process of reviews, either generally reviewing all social workers' decisions or in cases of complaints. So there's a ready, quick system to pick up potentially wrong decisions on the human rights test. And the other thing which I think needs to be considered is being flexible and responding to changing circumstances, particularly if, for example, you decided you don't need to provide support because there are informal support from family members. What happens if that family member then gets admitted to hospital themselves? We need to be ensuring that we're very able to turn around quickly and respond to those changes in circumstances. So I think that's my last slide, Zoe, is it? Yeah, so that's the end of our presentations. I think we've got now provision to have some questions and answers, but one thing which I will remind you of, again, which Zoe said at the beginning, this has been recorded, so you will all be sent a link, an email with a link to the recording of this seminar and also a link to the slides, so you'll have all of the documents available to you separately. So you can ask us questions through the Q&A button at the top or at the side of your screen. So shall we have a look at those?
Can I jump in, Lee, while you're reading these? Only because we had a question earlier that I forgot to address in my bit, and it was relating to key decisions. So these are decisions that you're making to activate the easements, and you'll recall that I said that the decision-making process was in the guidance, and that generally refers to the decision being made by the, for example, Director of Social Services on the recommendation or an agreement with a principal social worker. And the query was, well, that's what the guidance says in relation to decision-making. Do we then need to apply the criteria and the obligations under key decisions if we as a local authority consider that this is a key decision? You recall a key decision is where it has a significant impact on persons in your local authority across, I believe it's 2 wards. So likely to have a significant impact and be a key decision. My view is that the guidance is just looking at the decision-making process for the purposes of activating the easements. It's saying nothing as to whether, once that decision maker has made the decision in a proper way, that decision then needs to be ratified or made in a way consistent with your constitution as to key decisions, or in relation to the publicity requirements in the 2012 regulations as to key decisions. So my suggestion would be both. You need to make the actual decision in accordance with the guidance, and then you need to adhere to the 2012 regulations and your constitution relating to key decisions. Thanks, Lee.
That sounds great, thank you. One of the other questions I see here is about forms. That's the point I was talking about. That a lot of local authorities use electronic forms, which may be difficult to amend. I see that, and I can see that it would be difficult if you just had a bespoke, Word version form. So maybe the answer is to have a guidance note that is circulated to people, and you still use your forms, but ignore the boxes that are in your electronic forms, and just use the free text boxes more, so you can still record everything properly and electronically. I see that that's a problem, but I think maybe doing a mix of separate guidance notes for social workers plus using the current forms is probably the way forward. One other question I see is about rights to family life being difficult with social isolation, and in particular in respect of care homes. And I imagine the question there arises from care homes saying they're not going to allow family members in. And that's an interesting one, and it's one that I've certainly seen come up in some court of protection cases recently, where the reaction of most people in the official solicitor, it seems, in the court, certainly at the initial stages, was to be very deferent to care homes and accept that this is a very difficult situation for them to work out how to handle. But the thing I think to remember is that care homes that are supplying services to somebody under arrangements made by a local authority, the care home is treated, although it's a private company usually, it's treated as a public body for the purposes of the Human Rights Act. So it owes its own Article 8 obligations to the resident and to their family members, and it needs to ensure that it can justify any complete barrier on all contact and visits with a family member. Now, they may well be able to do that in certain circumstances, but they need to think about it. And so I think it's appropriate for local authorities to defer to the care home provider on that issue, and require the care home providers to make their own reasoned Article 8 compliant decision on whether complete bans on all people receiving visitors are compliant with Article 8.
Can I just add a wee bit in relation to that, Lee? As Lee said, there have been court of protection cases on that under the deprivation of liberty provisions. And in one case in particular that I recall, the court was, as Lee said, very deferent to the care home's view that they couldn't have visitors, but they effectively had to bend over backwards to find other ways of doing it. So that man in the particular case I'm thinking of, he was deaf, so he had to be taught or enabled or empowered to deal with Zoom and other social media ways of working. I think his family member, if I remember rightly, came up to the window at a set time so they could talk through the window. There was very detailed consideration given to maintain family life even within the ban on visitors. So yes, some thought will have to go through it, but at least in that case, the ban could be maintained. Thanks, Lee.
Thanks.
There's just one other question here that I wanted to address, which is someone's asked about how all of this affects assessments and care plans under Section 117 aftercare. So that's under the Mental Health Act, and said if at all. This goes back to the point I made. I didn't include the Mental Health Act before. I said about the Mental Capacity Act and about the Equality Act not being affected, but these provisions don't specifically affect actions that are taken under other legislation like the Mental Health Act. Now, of course, when you've got someone who comes under Section 117 aftercare, sometimes you have a split of their package where certain things are being dealt with as Section 117, and there are other things that if they have potentially physical ailments that aren't impacted in relation to their mental health, that would be being dealt with under the Care Act. So the Care Act part would apply to that to the Care Act provisions, but the easement provisions would apply to the Care Act part, but the Section 117 aftercare part would not be affected by these provisions.
I see one other about assessment forms. The question is, would the human rights assessment forms on the No Recourse to Public Funds network, the NRPF network, be sufficient for consideration of human rights in these cases? I think no, and I say that because my own view, might be controversial, is that the NRPF network forms aren't great for NRPF cases. I don't think they're as helpful as they could be. But also the reason why I think they would be ill-suited to these cases is, of course, for no recourse to public funds cases, often the human rights analysis is, could the person avoid a breach of their convention rights by returning to their country of origin, which is a complicated question to consider. But of course, that wouldn't arise in these Care Act cases where we're simply looking at the absence of services. Would they amount to a breach of human rights by reason of the ill treatment or the poor circumstances someone would descend into? So I'm not sure that the NRPF forms were going to be particularly helpful, but they may be a good starting point, but would benefit from a bit of tweaking at least.
Right. In that case, I think we've covered quite a lot of the questions. It's probably about time that we wrapped up. If anyone does have further questions that you haven't had an opportunity to ask, then you are welcome to get in contact with us, and the contact details are there at the end of the slides. We will try to do our best to respond to what we can. We can't promise to respond to every single question if there's a lot, but we will certainly do our best. And so that just leaves us to say thank you very much for joining us. And thank you, Peggy and Lee, for very informative talks. We will speak to you all soon, no doubt.
Thanks.
Bye.
Thanks all.